All right, so now we'll move on to what is false advertising. Does anybody have any other questions about the legal lay of the land? Okay.
A question about cease and desist.
Sure.
None of the clients in the room, but I have heard clients say, "Oh well, just do it anyway, and if we get a cease and desist, we'll pull it."
It's a risky behavior. 9 times out of 10, honestly, things, and this goes for trademark infringement and copyright infringement too, most of the time the cases are resolved without litigation and without payment of penalties or fees or damages. But you never know. And if something's out there, especially a national ad, then the costs to change it are significant. And you might end up in court if you have a very litigious competitor. And the competitor, or you have a litigious, if it's egregious, the FTC might look at it, or a state attorney general. So it's a risky proposition to do that. On the other hand, if an ad could mean an increase in market share of 1% in a big market, does it pay for itself? So it's a business decision. But
it seems like the PR aspect of it is the big unknown. If it gets picked up and gets to be a big PR thing.
That's right. Well, we'll talk about some of the, there's a case later about tax preparers who did same-day refunds. And that was found to be, I'm jumping ahead a little bit, but the same-day refunds, the New Jersey Attorney General, Ann Milgram, in February of this year, went after 40 tax preparers who were advertising same-day refunds. And of course, everybody knows they aren't really same-day refunds. They are anticipatory refund loans that are at predatory rates. And she levied hundreds of thousands of dollars of fines against these 40 people, these 40 tax preparers. And they were pretty small-time tax preparers. So you just never know. Something as simple as that everybody's doing, can still get picked up and create a problem. Do you have a question? Okay, wait, let me go back here. All right, I want to talk, this is the rule, this is the basic rule about false advertising. And there are several key words in this rule that we're going to talk about a little bit more as we go on. Verifiable claims must be accurate and substantiated, and as a whole, the ad must not be misleading. So, verifiable claims, verifiable being the key word, anything that's objective, anything that makes a statement, either an implied or an explicit statement about the quality or characteristics of a good or product or service, if it's verifiable, it better be right. And it better not only be accurate, but it better be substantiated. Because if it's not substantiated, then you didn't know it was right when you got the ad out on the market. And that's also a category of false advertising. And then furthermore, the ad, if it is not verifiable, the ad can't be misleading in any way. It can't be misleading by omission. It can't be literally true, but the message behind the literal truth is false. And so we're going to look at some of these cases, but this is the basic rule. Here are some of the key types of false advertising. Explicit falsity, we talked about the same-day refunds. That one was literally false. They were not same-day refunds. The IRS takes a minimum of 8 days to process refunds. The AG was able to point to that, and these people had no defense at all. And that's another thing, too, is with explicit falsity, there's a concept of materiality that pervades all of false advertising. And if a court or the NAD or the FTC concludes, based on a complaint, that something was false but it wasn't material to the purchasing decision of a consumer, then that's not actionable. On the other, but explicit falsity is deemed to be material automatically. So if you have something that's literally not true in your ad, then that's something that is automatically material and automatically actionable, and there's not much of a defense to that. Implied falsity is a little bit more complicated because that means that your statement may not be actually false, but something about the ad, something about the message that's communicated in the ad as perceived by consumers is misleading. And I love this case. This is one of my favorite cases. Everybody remembers Bruce Jenner, right? The famous athlete from the 80s and 70s. Let me just set the stage for this ad for you. Does anybody remember this ad? Does anybody remember the Bruce Jenner ad for Tropicana? Okay, because it was back in about 82 or so. I tried like I banned it to try to find the video, but it's contraband now, so you can't get it because they lost. I'll go ahead and give it away. But what happened was, okay, Bruce Jenner sits down and he's at a workout. He's talking about the benefits of orange juice. He's squeezing an orange and getting fresh juice out of the orange, and then he says it's pure pasteurized juice as comes from the orange. He takes the orange juice and dumps it into the Tropicana carton. Okay, so Coke, which owns the Minute Maid brand, said, "No, wait a minute. Pasteurization is a process, one, and two, it requires bringing the orange juice up to 200 degrees. So either that's a mighty hot orange, or you're not conveying it properly, exactly. And furthermore, evidence came out that that Tropicana ships their products frozen sometimes too. So it's a hot orange or a really cold orange, but it's not exactly the way Bruce Jenner was showing it. So that ad was pulled. Coke won that case, and that ad was pulled. And then now the ad that you can find on YouTube is very much a homogenized version that doesn't have this exact thing. But anyway, you can see that's not, it's just an implication that's misleading. Misleading by omission, there's a very famous case of Squibb versus Stewart Pharmaceuticals with, these are they're anti-blood pressure medicines, Capitan and Zestrol. I don't know if anybody knows about those medicines, but in that case, and this was one of these massive false advertising cases, it's one of the leading cases where incredible thousands and hundreds of thousands of dollars were spent on scientific studies to justify this is big-time pharma false advertising. So the claim was made. This was really kind of a close case too. In that case, and I looked at these ads, there's a chart. Zestrol has a chart saying, here are, and it's got, I should have put the ad up here, but anyway, it's got a chart showing the negative side effects of the Capitan product. Rashes, something called taste disturbance. I'm not sure what that is exactly, but taste disturbance. It showed these things. It showed problems, but what it failed to show was that the Zestrol product had been shown to cause headaches. And the court really focused upon that and said it was a material omission by you to show the negative side effects of Zestrol and omit to state the negative side effects of your own product. And that was one of the, these cases are funny, these legal cases, the decisions seem to hinge sometimes on the smallest thing. This was a massive case with massive scientific studies on both sides. It was a true battle of the experts. And it came down to just some of these small details that really mattered to the court. Does anybody have questions about these types of, there are plenty of other cases to talk about, but I'll move on and save room for questions at the end if there aren't any now.
What were the consequences on the orange juice? I mean, you talked
they had to pull the ad.
Market share, so they just pulled the ad.
They just pulled the ad. Yep.
A lot of awareness. They may have, gotten more market
Well,
share.
what they did is all they really did is change the ad. They reshot the ad with Bruce Jenner not doing that, not doing the pouring the orange juice into the carton. And you can see the ad that's out there today. It's still kind of a cult classic because it's Bruce Jenner, and you can see it. It's the same exact ad, same script. He just doesn't do that one little bit. So
Production cost consequences.
that's right. And I think it was a case. It was a fought case, so there was some battling over that. But generally speaking, there were no damages issued. So
Jay, with the Zestrol case, if they would have just put in the legal type, they would have put can cause headaches, would they have been okay?
Those disclaimers, there's a lot of FTC guidance. And by the way, anybody who's interested in this topic, go to the Federal Trade Commission website, and there are tons of policy statements and guidelines on every type of issue, including disclaimers. And it's hard to say. It's a factual matter as to whether that would have solved the problem. What they really needed to do, according to the opinion by the court, was put that fact into the chart, not only put it in the disclaimer, because it was a head-to-head comparison with another product, and it needed to be fair. So, but that's an interesting. You wonder if somewhere else in the ad, if they had done that, it could have solved the problem. They didn't.